Good morning, everyone. Welcome to CWM Sealand Weekly Meeting. Today is May 18th. Today's topic is New Jersey Law Against Discrimination. We call LAD, L-A-D. So we want to take a look at what kind of issues, first of all, frequently arises, and what we can do and what we should not do. And also we're going to talk about the penalties. Well, by the way, this content is from New Jersey Attorney General's memorandum. As you can see, this memorandum is to all property owners. So addressing to property owners. Actually, this memorandum not directly addressing to licensees, but property owners. Okay, so in fact, we should let property owners, in other words, when we try to get the listings from the property owners should know these contents about NJLAD. It's from John Hoffman, Acting Attorney General, State of New Jersey, and also Craig Shashihara, the Director of NJ Division of Civil Rights. In any case, if you violate any discrimination law, someone can file you to Division of Civil Rights. So this is the organization who handles most of the housing discrimination cases in New Jersey. And it's dated August 2013, and subject is housing discrimination laws. Now, I have a question to you. Do you know where you can find this Attorney General memorandum? It's not something I dig out, in the Google search, etc. In fact, this memorandum is nearby you every daily life. Isn't it interesting? But I realize that many realtors, they are not aware of where this memorandum actually is posted. This memorandum is, in fact, the back of the, for instance, NJMLS listing agreement. Okay, so if you have a doubt, you print out NJ MLS listing paper and flipped over the page. In the back page, it has exactly this type and the to, from, date, subject. Okay, in other words, whenever homeowners signs listing agreement with licensees, homeowner should read this, okay, clearly, because this is a memorandum to all homeowners, as you can see here. Okay, so all this context is addressing to homeowners. Okay, of course, as licensees, we, of course, learned the state real estate licensing law and also rules and regulations from commission. But this specific memorandum is addressing to homeowners. So that's why, of course, this meeting is open to public, and I hope many participants from public are aware of this memorandum as well. Okay, it says here are some issues that come up with frequently in enforcing the LAD. Number one issue, discrimination based on source of lawful income used for mortgage or rental payments. This means, for example, the landlord cannot reject a prospective tenant because he or she intends to rely on a Section 8 voucher, a rental voucher, or FEMA voucher issued to Superstorm Sandy victims, or other types of rental subsidy. In other words, owner cannot say, oh no, I don't accept the Section 8. If owner mentioned that, that itself is it's a violation of LAD already. They cannot say no. Not because of Section 8, but because of something else, maybe the prospect tenant's financial situation. They can say no, but not because of the Section 8. Many agents, many licensees don't know about this. And homeowners also, a lot of majority of homeowners do not know. Okay. Number 2 case, no pets rule cannot be enforced to prevent a person with a disability from using a service animal, such as a guide dog. Well, owner can say, I don't accept pets. Yes, they can say that. Okay. That is not discrimination. So there is no discrimination law against animals. In other words, owner can say, no, I don't want to have cats. I don't want to have a dog. Yes, they can say that. However, exception is they cannot say no to service animal, typically with certificates. So in this case, if owner says no to the prospect tenant with the service dog certificate, then the owner is violating LAD. But a landlord may charge a tenant with a disability an extra fee for keeping a service dog. Well, this is a good news to a landlord, good news to homeowners. Okay, they cannot say no to the prospect tenant with a service dog with the certificate, but owner can charge extra money for that service dog, to keeping a service dog. That's good news. Number 3, discrimination based on familial status prohibits discrimination against families with a child or children under 18 years old and includes pregnant women. Okay, in New Jersey, by the way, we're talking about New Jersey, okay? Federal is different, okay? But we have an immediate area that we serve is New Jersey. So we have to go by state. So if some prospect tenants has a child or children under 18, and some homeowners say, no, I don't want to have a child, that's violation against LAD, including pregnant women. The owner cannot say, no, oh, you're pregnant, and I don't want to have a newborn baby in my apartment. Owner cannot say that. If they do that, that's violating the LAD. And number 4, among the many cases, but number 4 may not be that frequent, but landlord must permit a tenant with a disability. Okay, landlord must permit a tenant with a disability at that tenant's own expense to make reasonable modifications to the premises if such modifications are needed to give the tenant full enjoyment of the premises. Okay, well, this means a landlord cannot say no to disability. They cannot discriminate a disability. but owner can make a reasonable modification to the premises, but that cost is responsible for tenants. So at that tenant's own expense, they can make a reasonable modification so that the tenant can enjoy the premises. Well, whether real life this is happening, well, not many cases, but we need to know what a law says. The law says this exactly, number 4. Okay, so these are the typical issues in enforcing the LAD. But of course, beyond this, a LAD specifies 18 protected classes in New Jersey. Okay, we don't want to go to all these 18 classes to be protected, but most of them is basically we can figure it out from common sense, right? Okay. Now, what's the penalty we're talking about if you violate? Okay, and what is the penalties? If you commit a discriminatory housing practice that violates the LAD, you may be subject to penalties not exceeding $10,000 for the first violation. Okay, so for example, somebody filed against you, and then they found it's you really truly violated the law, LAD, then it becomes your first violation, and you probably pay the money, but up to $10,000. So below than $10,000, you have to pay, depending on the judge, the community decision. Basically, the Division of Civil Rights handles this, and not exceeding $25,000 for the second violation within 5 years. So if you violate second the violation within 5 years of first offense, then your penalty becomes up to $25,000. Okay, up to $25,000. And if you violate 2 or more violations within 7 years, then your penalty, you may have to pay money up to $50,000. So I guess after first offense, okay, you paid, let's say, $8,000, and in 5 years you didn't violate. Okay, then 6 years you violate again, and that means you're gonna pay the penalty up to $10,000 because it's beyond 5 years. But if you violate second case within 5 years, your penalty can be up to $25,000. That's what it means. Okay, now it has a content to brokers. Regarding brokers, well, it's a common sense. The broker and salesperson with whom you list. See, who is you? Who are you? You is homeowners, okay, because this memorandum addressing to the homeowners whom you list your property must transmit to you every written offer he or she receives on your properties. This memorandum to homeowners, okay, so homeowners should know this. It says person you signed the list with should transmit to you every written offer. Sometimes licensees, sometimes agent, look at the application and, well, this is no good, and they didn't report to, they didn't transmit to, they didn't present this offer to owner sometimes. That's no. Brokers and salespersons are licensed by the New Jersey Real Estate Commission, and their activities are subject to the general real estate laws of the state and the Commission's own rules and regulations. This is how they specify. And the underlined portion is very important, that all homeowners should know about this. Ironically, this message is to actually, not ironically, but it's kind of interestingly, this message is to actually brokers and salespersons. The broker or salesperson must refuse your listing, you means the homeowner, if you indicate an intent to discriminate based on any of the protected classes. Okay, so this any of protected classes means the typical issues that we talked about here, 1, 2, 3, 4. Okay. Anyway, homeowners, this is what they're saying. If homeowners try to do, let's say, for example, okay, I want to have only Korean tenants in my apartment. Can you look for a Korean tenants? Then what are you going to say? If you are the listing agent, you brought your listing paper with this homeowner, and homeowner says, oh, by the way, before I sign this listing agreement, can you look for Korean tenants? I don't want to have any other people except the Korean tenants. But then you're going to say, oh, sorry, you cannot do that. You cannot even mention that because you are violating the law. And then owner says, no, still I want to have a Korean tenant only. Then what do you have to do? This is what they're saying. The broker and salesperson must refuse your listing. Okay? Again, broker and salesperson must refuse your listing if you indicate an intent to discriminate based on any of the protected classes. Okay, so I think we covered kind of essence of this New Jersey law, especially most frequently comes up. Okay, all this Section 8 case and the service dog case, and also the babies and younger children case, including pregnant women, and disability case. Okay, and then penalty, and brokers must know the situation. Okay, and then exemption. There are 4 exemptions of this lad. First, renting an apartment in 2-family dwelling if owner lives in the other apartment. Let's say a 2-family house. Okay, one section, 2-family house, one side either up and down or side. Homeowner lives in the apartment. Then the renting the other apartment, okay, is exempted from the LAD. And also renting a room or rooms in a single-family dwelling if owner lives in the same room, just kind of room and board, right? In that case, if owner lives in the house, then it's exempted from the LAD. And also, religious organization can give preference to person of the same religion when selling or renting real property. So, for instance, in a church situation, that's exempted from the LAD. Okay, and they can sell to the same, let's say, type of religion. Okay, when they sell the property, even or renting the property, they can do that. That's exemption. And in certain types of housing designated for older people, I think they mean the it's a senior house, senior apartment. it is not unlawful to discriminate based on family status. They have their own kind of rules. Okay, so these are the exemptions. So you need to know exemptions also clearly. Okay, this is essence. 지금 말씀드린 게 그 하우징 러의 에센스라고 할 수 있는데요. 이게 이제 그 어토니 제너럴 메모랜덤 2013년도 8월 달에 모든 홈오너에게 보내진 그러한 공문서죠. 말하자면 스테이트 정부에서 모든 홈오너에게 보낸 공문서다. 이렇게 보시면 되겠어요. 그래서 여기 to from date subject. 근데 이거를 어디서 찾을 수 있냐면은 물론 이제 처음에는 13년도에는 무슨 신문에도 막 나오고 그랬겠죠. 크게. 지금은 어디서 찾을 수 있냐면은 여러분들이 NJMLS 같은 경우에 MLS 리스팅 페이퍼 뒤에 보면 이 메모랜덤이 나와 있어요. 그러니까 사실은 이 메모랜덤은 누구한테 보내는 서한이냐, 누구한테 보내는 공문이냐, 홈오너들한테 보내는 공문이에요. 그 홈오너들한테 알리는 게 목적이라는 얘기죠. 오케이? 그래서 지금 첫 번째 많이 일어나는 케이스를 여기 요약해놨거든요. 그 공문에 보면 뭐냐 하면은 source of lawful income을 discriminate 하지 못한다. 즉 예를 들면 섹션 8 바우처를 가진 사람을 섹션 8은 난 안 받습니다. 이렇게 하면 걸린다는 얘기예요. 또는 페마 바우처라든지 자관 정부에서 어려운 사정들이 있으셔서 subsidizing 하는 그러한 바우처들을 노하지 못한다는 거죠. 그 다음에 이제 펫 문제가 많이 걸리잖아요. 펫 문제는 clearly 펫은 주인의 재량에 따라서 노할 수 있어요. 고양이를 안 하겠다, 덕 가진 테넌트를 안 하겠다 할 수 있는데 except 서비스 덕이라고 그래서 서비스 애니멀 such as a guide dog. Okay. 그 경우에 서티피케이션이 있다. 그럴 때에 주인이 그게 그러니까 서비스 덕이 있어서 나는 이 테넌트 못 받겠다 하지 못한다는 거 하면 바이올레이션 된다. 자, 그 다음에 물론 서티피케이션 물어봐야 되겠죠. 근데 이제 한 가지 좋은 점은 랜로드가 그 펫이 있다. 예를 들어서 가이드 덕이 있다. 서비스 덕이 있다. 그래서 그거 덕하고 살아야 된다 하면 서티피케이트 체크했어요. 그때는 그것으로 인해서 더 차지를 할 수가 있다. 엑스트라 피를 차지할 수가 있다. 그건 법적으로 보호받게 돼 있단 말이죠. 뉴저지 내에서. 그래서 그렇게 하시면 된다. 그 다음에 뭐죠 이게 18year 그 영거 children을 있다고 해서 얘네들이 방방 뛴다고 뭐 소리 난다고 이런 이유로 해서 거절하면은 그것도 지금 걸리게 됩니다. 오케이. 그리고 이제 임신부도 거절하면은 걸리게 됩니다. 그 다음에 disability, 일반적인 disability도 사실 무조건 disability에도 나를 안 받겠다 하면 안 되는 거고, 그거를 이제 modification을 해서 단 테넌트가 페이 한다고 할 때에 테넌트 expense예요. 그때는 modification을 만들어 줘야 된다. 자, 그런 굉장히 자주 일어나는 케이스들이 있는데 페널티는 여기 지금 아까 다 한 거죠. 그래서 첫 번째 바이올레이션이 인정이 되면 up to $10,000. 두 번째는 $55,000. 5년 안에 두 번째가 발생했을 때, 그다음에 7년 안에 두 번이나 이상 또 이제 바이올레이션을 했으면 5만 불까지도 가능하다. 그런데 이 노티스의 재밌는 거는 뭐냐면요. 이 주인들한테 보내는 노티스에 참 이 재밌는 로직인데 주인들한테 보내면서 당신이 뉴저지에서 얘기하는 18개의 프로텍티드 클래스를 베이스로 디스크리미네이션을 하려고 하는 인텐션을 보이면 이 브로커들은 에이전트들은 당신의 리스팅을 리퓨즈 해야 됩니다 라고 나와 있어요. 오케이? 그거를 잘 한번 생각을 해보셔야 돼요. 그래서 저는 이 세미나 같은 게 좀 퍼블릭이 많이 들어왔으면 좋겠어요. 그 이유가 퍼블릭 분들도 너무 모르는 거예요. 이 메모랜덤이 나간 지가 언제일 텐데 2013년도 어거스트인데 그러니까 이런 것이 영어로 나가서 전달이 안 되고 하니까 아무도 퍼블릭한테 누가 교육해 준 사람이 없잖아. 그러니까 점점 모르고 이런 것들이 있는 것도 모른단 말이죠. 만약에 이분들이 요 한 30분만 이 얘기를 들었으면 조심을 할 거예요. 최근 한 작년 케이스인가요? 팔리시드 파크에서 케이스가 있었죠. 이탈리언이라고 안 보여준다고 그랬어요. 그거를 또 그대로 테넌트 에이전트한테 얘기를 해가지고 테넌트 에이전트가 또 그대로 이탈리안 테넌트한테 얘기를 했네. 프로스펙트 테넌트한테. 그래서 이탈리안 분이 디비전 오브 시빌 라이트에 파일을 했어요. 그러니까 이게 많이 좀 교육이 돼야 되는 그런 문제가 있다. 그런데 예외적인 게 있다. 예외적인 것도 알아두시면 좀 편할 수 있죠. 만약에 투 패밀리 드웰링 같은 경우에 투 패밀리 하우스에 한쪽에 주인이 살고 있다. 그래서 다른 쪽을 렌트 줄 때는 예외예요. 디스크리미네이션에 해당이 안 돼. 그 다음에 주인이 살고 있고 하숙을 한다든지 룸앤보드 하잖아요. 그때도 해당이 안 돼요. exemption. 그다음에 종교기관이 스페이스를 렌트하거나 물건을 팔 때도 exemption 예외가 된다. 그리고 이제 시니어 하우징의 경우는 패밀리 스테이터스를 디스크리미네이션 해도 그걸 분류해도 받고 안 받고 해도 법에 걸리지 않는다. 그런 예외가 있다. Okay, this is a sort of summary of Attorney General's memorandum. The title was Housing Discrimination Laws, published 2013 August. And mostly we can find this memorandum easily on the back page of, for instance, New Jersey MLS listing agreement paper. Okay, any comment or any questions regarding this? Then you can unmute and you can ask.